This podcast may contain disturbing content for some listeners. It's intended for mature audiences. Listener discretion is advised. This is True Crime XS.
I had a piece of true crime news. I had a couple of pieces to choose from this week. I went with this one because I had followed this. This was a really interesting kind of crazy thing that happened out of Louisiana. Now, it happened a while ago, and it's one of those things that comes with a viral video. And I didn't see the video at first. I just saw all these little like snippets about it. And of course, one person was one race and the other party was another race. So there's it showed up in publications very clearly marking it as maybe a racial issue. That doesn't seem to be the case. And the reason I'm bringing it up today is because it just spent so much time in the court. But hopefully it's sort of the last of it. I pulled it up on NOLA, and then I pulled up, I think ABC had a good write-up on it. But NOLA had the best summary of what just happened, and then I'll kind of tell the story as we go. It's by a guy named Matt Bruce, and I think he put it up on April 30th. It's been updated since then, but I think April 30th, 2024 is when it first went up. So what this story is about is a woman during a storm was very upset that water was flooding into her house from a nearby road. And she and a couple of men were standing outside of the house during this heavy, heavy downpour. And for some reason, she decided that she needed to have a baseball bat. And there's a car going by, and if you find the video, the car going by is where we see the video from. But basically, a person going by has picked it up sort of mid-confrontation, where this woman is swinging the bat, and then it keeps going, and a gun is pulled out. There's a lot of commentary back and forth. It's important to note up front, nobody gets hurt here, except for feelings. A lot of feelings get hurt.
Baby, first of all, don't curse at me. That's what you don't do. You need to control her, stupid. I'm sorry. Your wife hit our car. I'm finna call the police. Dial 911. We understand y'all fully, but y'all got no business doing no damage to our damn car.
She still ain't gotta be in the truck, man.
I know. I'm sorry, man. Let's...
No, y'all need to control her for real, because she done cuss me out. I'm a child. She done cuss me out. She tripping.
I know, baby. Just keep rolling. Look.
Ma, get in the car.
Go ahead, baby. Go ahead.
Ma, get in the car. Oh, Ma, get in the car. Ma. Y'all, she done pulled a gun out on us. She tripping.
Get in the truck, baby. You ain't got
She done pulled a gun out on us, y'all. She tripping. I'm finna call the police. And I got her on camera trying to hear our call with a bat. Yes, I'm calling to make a report. I'm in my subdivision trying to get to my house on a flooded street. And the lady comes out with a bat, hits my truck with a bat. And then I asked her, why would she hit our truck with a bat? She goes in her house, get a gun, and comes back outside and point at us while we trying to drive slow, trying to get off the street. And I want to press charge. And she started screaming. What is she screaming for?
And there's 4 foot of water everywhere.
Yeah, it's a high stress situation, and I'm not justifying what anyone did here. I'm just flat out stating that something that happens here is very strange. The woman's name, who is at the center of all this, is Bridget. I think it's DiGirolamo or DiGirolamo, something like that. She was a phys ed teacher at a Baton Rouge elementary school. And this flooded street confrontation happened in 2020, and it's sort of been slowly winding its way through the courts. And you can go on and see that a couple of people have covered this, but it really didn't get like major news coverage, this last part of it. So according to one version of the story, she had been trying to call 911, and that's Bridget. She's trying to call 911 in Baton Rouge, and she can't get anyone on the phone. But the driver of the car gets 911 on the phone right away. And so this is all happening on July 6th. Once the woman that's a driver gets on the phone, basically she says, there's a woman out here with a bat. She's yelling at my car. There's standing water from the storm. She's cursing at us. And she has hit the side of our car and the tailgate of the car with this bat. And she went inside. She retrieved the gun. And the deputies get there after all of this has occurred, by the way. But the victims get out and they check the car. And the woman goes in her home. Bridget goes in her home. She comes out with a gun and tells them that they better move. So that's the point where we get that they leave the area and this 911 call happens. They charge the elementary school gym teacher with felonies. So she gets hit with 3 counts of aggravated assault with a firearm. And I think she has a damage to personal property or some kind of criminal damage to personal property. The charges get bumped around a little bit. It ends up going to trial. And that's sort of where we pick up today. I have heard of something like this happen before. Before I say what it is to the audience, had you ever heard of anything like this? As far as the legal part of it?
No.
Okay. First of all, this goes to a jury trial. I just want to say that again because I don't know if people understand like the concept of something like this going to a jury trial. This is a felony jury trial where you've got an elementary school teacher who is basically facing about 10 years in prison. If she has no criminal record, that's like probably 5-year sentence, 5 years suspended, a bunch of stuff she has to do. I'm going to read from some of these documents here, and I think that'll make more sense. For the record, if you go looking for this, Justia has a lot of the orders on there, and a lot of those are really short. It's hard to piece this whole story together, which might be the reason it's not covered as much. But the advocate has it, and then Matt has it at NOLA. And we'll just run through what happened so that people can understand why I'm still talking about this. The judge here, by the way, is named, it's Ebony Johnson Rose, according to this. Okay. She goes on trial in February 2023. It's a 3-day trial. And she's been indicted at this point in time, like in 2024, when we're putting all this together. She's been indicted, found guilty, acquitted, convicted, then ordered to be tried again after a judge declared a mistrial. Did that make sense to you the way I said it?
It makes sense to me, but I don't think that's what happened.
That's sort of what happened. In February 2023, when the jury goes out and deliberates and comes back, they have questions. And Bridget is initially found not guilty of felony aggravated assault.
This is the very first, they just had the trial, they're deliberating, right?
They're deliberating.
Okay.
13 minutes later, so she's been told, go home, we're done, move on, you're free to go. And that's it.
And she's acquitted of all the charges.
She's acquitted. But 13 minutes later, District Court Judge Rose, she calls the attorneys back into the courtroom. She has consulted with the jury, the jurors, ex parte, meaning the attorneys weren't there, the defendant wasn't there. And she realized that they had meant to convict Bridget of lesser charges, not to acquit her entirely. So this 13 minutes passes. So the judge then issues a new verdict and finds Bridget guilty of misdemeanor aggravated assault. Well, the defense attorneys in this case say, that's not how any of this works.
Except that's a judge telling them that.
But it's a judge doing it, so they don't know what to do.
But just to back them up, that is not how any of that works.
Right. The judge ends up having to recuse herself over this after the defense attorneys file a motion saying, this is not valid, and we're not even sure what motion to file because, there is no, what happened has no protocol. So it gets assigned to a district judge named Louise Hines Myers. She hears the defense objections, and she decides that the best thing she can do in December 2023 is to declare a mistrial. And the defense attorneys look at her and say, I don't think that's how this happens either, because the verdict's already been rendered. And so the defense attorneys appeal it, and it gets kicked up to the First Circuit Court of Appeal in Louisiana. And they look at it, and in February of 2023, they say, okay, we're going to uphold Judge Myers' ruling. And the mistrial stands. So the retrial starts to be put on the calendar, meaning this woman is going back on trial for the felonies that she's been acquitted of, and that the misdemeanors really have nothing to do with this. It's going to be headed to a July 11th hearing, and that's going to be in front of Judge Myers. The defense attorneys look at this in February after the First Circuit upholds the ruling, and they say, this doesn't make any sense. So they file an appeal with the Louisiana Supreme Court. And the Louisiana Supreme Court finally looks at it, and they say, we can't even tell what's happening here, but that's not how we do things. So they overturn the mistrial, and they reinstate the jury's original not guilty verdict in Bridget's case. And of course, Bridget's attorneys came out and said, we believe the unanimous Supreme Court decision is a right decision. We're happy for Bridget, we believe is innocent of these charges. Justice Scott Crichton, he pens a one-page concurrent opinion and basically says that Ebony Johnson Rose is ridiculous. That's the judge who handled the first trial. And he cited numerous parts of the judicial code for the state of Louisiana and said that the first thing that a jurist must be is professionally competent and impartial when they're recording these verdicts and walking through these post-deliberation processes. And he said, here, the trial judge's blatant violation of these laws shocks the conscience. Chief Justice John Weimer offered a concurrent opinion with a relatively tempered tone. He said, unfortunately, a mistake was made by a relatively new judge. Our role in the case immediately before the court is to review and, where appropriate, correct a mistake so that this judge and others can learn, make corrections, and not repeat the mistake. To castigate this judge in this case is simply not the proper forum because of the need to evaluate and consider far too many facts which are simply not in evidence in this matter. Passing judgment on the judge at this time, in this form, on this record, could itself implicate the Louisiana Code of Judicial Conduct and result in recusal. Judge Johnson Rose had been a judge for 2 years at that point. She assumed office at the beginning of 2021. She is 3 years into her term at this point. Her term will end in December 31st, on December 31st, 2026. She declined to comment when asked about this.
I think that was probably a smart move.
They're not. Jurists aren't supposed to comment on matters before them, anyways, even if they've recused themselves.
And so, the implications of this case essentially are, regardless of the facts of the evidence of the charges against the defendant, right?
Right.
There's ramifications here that are, I agree that it is shocking what the judge did because, essentially, when you're in court and you're on the record if it were to exist, like this is a formal, what's here is what is happening record, right?
Yeah.
Like there's in our justice system's interpretation of what being on the record is, it means like once the foreperson has handed over the verdict form to the judge, and the judge or the clerk or whoever reads it into the record, that is what has occurred, right?
Yeah.
And so, having been found not guilty of all charges, it would actually bring implications of something akin to double jeopardy into play, to do anything to change that without going through the proper channels, right?
Yeah.
Okay. And so this was an acquittal that what did Ebony Johnson Rose change it to?
Okay, so here's how this went down. So the deliberations only lasted about an hour. It's more than an hour, like after the break, if you like read it, but it's not. It's an hour and change. They returned with a verdict, but they had some questions, and the questions aren't to do with the case. The questions are to do with forms. So they come back in and they give over the verdict sheets. The 3 charges she's tried on are not guilty of felony aggravated assault with a firearm. And I guess there's a question related to the judge's instructions. So the jury instructions might have been at issue here too, but that's not in front of me right a second. A clerk reads the verdict out loud, and then the defense attorneys asked the judge, Ebony Johnson Rose, to poll the jurors. And so all that is the defense asked that the jury's responses be read into the record. And she says, juror number 1, juror number 2, did you find
is this your verdict?
Yeah, is this your true verdict? And they just say yes or no. Well, while they're doing that, the defense attorneys realize that the verdict isn't unanimous. So the judge sends them back out to deliberate again, and they have more questions. So they come back with another question, and I don't have the questions in front of me, but basically it's related to the jury not understanding the verdict forms. So in just a couple of minutes, they come back in, and Ebony Johnson Rose gets their jury sheets from the clerk and is looking at them, and like it doesn't, again, something happens where she's looking at it and it doesn't make sense. So she hands it back to the clerk. Clerk hands it to the deputy. Deputy takes the jury back out, and they refill out the jury forms. 10 more minutes go by, and the jury comes back in, and the jury has filled out the forms to give a full acquittal of the felony charges, clearing Bridget of all the charges. So at this point in time, Ebony Johnson Rose, she excuses the jury, thanks them for their service, and clears out the courtroom.
And the defendant is acquitted of every charge.
Right. So she then meets with the jurors alone afterwards. And her intention has nothing to do with the verdict. She's trying to figure out what the problem was between the instructions she gave them and the way they came back in 1, 2, 3 times, like with different things checked out. And talking to them, they say that's when the judge realized that the jury hadn't meant to acquit Bridget entirely. They were just trying to make it so that she was found guilty of only misdemeanors instead of the 3 aggravated felonies. So Judge Johnson Rose calls the defendant and the attorneys back in at that point, and she reads the verdict aloud, convicting her of those lesser charges. There's so many problems with that. Like the problems there are numerous in terms of like ex parte actions happening between a judge and a jury. That is a no.
Right. And while, I don't necessarily, I feel like there is some proper way for the judiciary to figure out what the disconnect is, right? it's not that. Because a jury makes a decision. They ask questions. They came in and out. Like, that is just a really bad sign. I'm just saying. As they're sitting there and they finally come to the verdict, or when they've asked questions, and I do think it's weird that things keep changing really fast, right? Like, guilty, not guilty. Like, did they just give up? Like, what's happening, right? But when you impanel a jury, they all raise their hand and they swear or affirm that they're going to take this oath seriously and do their civic duty, right? And it is 100% reliance on that. There's very little in the way of like checking and balancing. Did they actually do that, right? But the judge answered their questions, right? Whatever the answer was and however it was interpreted at the moment, it is what it is. If they had further questions, they should have asked further questions. Whatever the disconnect was, I have no idea, but it doesn't really matter because once it's been accepted, it is what it is. It's been entered. You can't, there isn't anything to be done at that point. You can appeal a conviction, but not an acquittal, right?
Yeah.
And so I feel like the other thing is the way that it now, granted, I guess you were reading from the actual opinion of the narrative.
Yeah, I was pulling different things here. Sorry.
And so that's slightly different, but still, once the jury's made its decision, it's made its decision. This takes it off of the jury and it spins it around in the judge's mind through this ex parte discussion that they have, during which, the prosecution's not there, the defense isn't there. There's nothing happening as far as the adversarial process goes, right?
Yeah. And
then she's like, oh, well, this is what you meant to say, right? Well, that's not really how this works. They had to, while it may have been an error, it was an error that was accepted. Now, I guess I do sort of understand why the judge that took over after she recused herself just declared a mistrial, right? But because I think they were like, I don't want to get involved in this, right?
Yeah.
And so then the next thing was the First Circuit Court of Appeals affirming
the mistrial.
The mistrial, right.
Because they also did not know what to do with it.
Well, and to me, it's very clear. The time to question a jury's verdict is really never, but because it, inevitably happened here, it would have been before it was formally read into the record. It's kind of interesting that the judge is never really supposed to directly address the jury in this type of context, right?
Yeah.
The judge is not supposed to tell the jury what to think. The judge gives the jury the laws that they are to apply the case that's just been presented to them to. They're supposed to apply the facts of the case before them to the laws, right? And they break it down, and these are pattern jury instructions, right?
Yes.
And they are specifically outlined, and it's a direct correlation with the charges that the defendant is facing. And so it's did you find this, that, and the other? If so, this person is guilty. If not, they are not guilty. It's like that. It's very straightforward.
Yeah.
And so that's how it's set up. A one-on-one with the judge, it just doesn't happen. That's not a situation that is allowed in our judicial system. And, it does make there's a lot unbalanced about juries, right?
Yeah.
Like as far as like what you're getting in jury situations. But the idea behind that is like, well, that's what there is, right? You have a pool of people who can put themselves in the position and then take in everything that they're being presented with and make a decision, as opposed to a judge making a decision. And but you know, that's a bench trial, and you can have that if that's what you want.
Right.
But a jury trial, it considers all these nuances of people not understanding this, that, or the other, right?
Right.
They try to clarify it. There are proper ways to get more clarification. This is not one of them. And, you know, beyond the merits of the case, this was a little astounding, right? That it had to go all the way to the Louisiana Supreme Court. And the Louisiana Supreme Court had to say, basically, no, judge, once you've acquitted someone on the record pursuant to the forms the juries have handed in, right? And you've accepted, you may not go have a discussion with them and then rescind the acquittal and convict them.
Right.
And I have a feeling they're all sitting there going, why are we having to say this out loud? Like, this doesn't make any sense. This is a given, right?
Yeah. So this is an interesting case itself without all these twists and turns at the end. And I think what threw the jury off is if you read about this or if you poll like the witnesses on this, and I don't know exactly who it is yet because I can't tell. It just says witness. It said that the driver, the person who is driving and whoever is filming, someone in their car makes fun of Bridget. Now, I'm not saying her response is correct. I'm just telling you this is how I think that situation escalated. There's commentary, whether this is true or not, I don't know, but that it like a yelling went on and they said something to the effect of, you better not bring a bat to a gunfight. And then the woman went inside and got a gun. So to some degree, I interpreted that if it's real, it could potentially be a threat. Like you're standing there with a bat. I don't know why you're standing there with a bat. You have this water rushing into your home. I don't know why you have water rushing into your home, but it's a terrible situation to be in. And someone says something about your bat being inappropriate or ineffective against their gun. So you go and get a gun. This is an example of people, first of all, I don't know why people film stuff like this when it's clearly like a situation that you get out of. Like you don't slow down to film things, you drive away. I could see how a jury would look at all of that and probably go, all right, well, we got to convict her of something because she did a thing, and go with the misdemeanor, and then the judge's actions after that notwithstanding, that might be the right call in this case to like hit her with a misdemeanor, but I don't think that was an option for them. It's not really clear that it was an option for them. And I say that because the judge has another issue, but I'll bring that up in a second. You got anything else on this one?
Well, just along with what you were saying as far as this goes, they're in the video that is depicted as the evidence of this case, right? It seems like they are very concerned about her hitting the car with the bat as if the 4 feet of water that is seeping into the vehicle as they're driving isn't doing any damage.
Right.
And so this is a dumb case. It was dumb for the defendant, Bridget, to go out with a baseball bat and try and like stop traffic, right?
Or I think she was trying to escalate them. I don't think she wanted them to stop them. I think she wanted them to keep moving and not like on the side that was moving more water. She was trying to redirect traffic quickly.
Well, I'm pretty sure that this did not help that.
No, it did not.
And so, like, I don't know why she had a baseball bat. I feel like there are, a bright orange vest and like talking to somebody probably would have gone a lot better. Those people weren't trying to flood her house.
They had no idea what was happening. There's no way to know.
Nor did it matter, right? There's no way that traffic was going to stop. There was something to do with traffic that when traffic was going through, it was causing like a little more water to go in the house, right?
Yeah.
That's on top of the massive amounts of water that were already in the house that I could see, right? I mean, it was crazy. And so I get where everybody was frustrated, very upsetting. She goes with a baseball bat to like make people hurry up and go or whatever's happening. I don't even know what's happening. But it's a stressful situation, and everybody should have like taken a deep breath, and the prosecutor should have thrown this case out because, nobody should have pulled a gun. Nobody should have pulled a bat. And I get that like those are how lessons are taught, right? But like everybody's standing in like 4 feet of water. And there's just nothing good about this. And then I feel like, but the only reason I'm seeing this at all is because the judge did what she did, honestly, because I never would have taken notice of this case otherwise.
The judge is what makes it interesting. I was never going to talk about that viral video without this component to it. And I say that because I think it's one of those things where you're looking at people in their worst moments. Like everybody there is not having a good day. And
they're feeding off of each other's misery.
Yeah. And I don't believe anybody here, like, I don't know how to explain it, but like everybody in the video and stuff, they're all wrong. Everybody's wrong. I don't care what anybody tells me about, but they should have filmed the damage or whatever. No, they should have got away from her because she's crazy. In that moment, she is not that's not a healthy person to be around. You need to move on because if they would have just kept driving, none of this happens.
Well, if somebody has a baseball bat, you do not stop and ask them why, right?
Yeah.
I'm just saying, but they are in a lot of water. There's a lot of people sort of walking around. It's a terrible situation, but the interaction, like, it's sort of like trolls on the internet. Do not engage, right?
Yeah.
And I feel like that would have been a really good, like, thought to have here, unless you're going to help, right? Unless you're going to say, oh, let me help you, right? Don't engage because like there's nothing good coming out of that situation. And neither one of those people were going to shoot the other one. And if they did, what would it have been for? Because they were upset? I mean, there's just nothing. There's nothing about the situation that should have been in court to begin with. None of them should have been brandishing weapons. And like, we should forgive people for the things they do on their worst day. Like you said, this is like everybody having a bad day.
Yeah. And like ultimately, like were some crimes committed here overall? Like I can't tell because of how everyone reacted. I can just say that the cops dispersed it and they chose to make an arrest. And then it's
insane. They're in 4 feet of water. Can you imagine that?
I think there's much better uses of resources in that situation than this. I did want to point out one more thing about this judge. You would think the judge learned the lesson from the February 2023 trial, right?
I don't think so. I doubt very seriously she ever learns this lesson.
You don't think that she would go, like, maybe I shouldn't change the verdict in the future?
I feel like if you know, you know. And if you don't know, you're never going to know.
Okay, so I want to tell you about this because I think it's fascinating. March 26, 2024. You can read this on WBRZ. Now, I'm going to read part of this just kind of note for note. It's from the WBRZ staff. out of Baton Rouge. I'm just going to read this article. It's really short. And it says, after a day and a half of testimony, a judge found a former Baton Rouge Police Department officer guilty of malfeasance in office for a 2021 alleged assault. Okay? Nearly 3 years before this trial, former officer Donald Steele was accused of luring a 19-year-old girl to a secluded location after a traffic stop and threatening to arrest her if she didn't comply. Steele allegedly made sexual advances toward the victim, groped her, looked through her phone, and sent her explicit messages. WBRZ reported that Steele was on duty, but outside of his district without proper notification to his superiors or supervisors. Steele had also turned his body camera off. Steele gets arrested and then placed on administrative leave, and he's fired from the department a year after his arrest. During testimony Tuesday, so that would have been around March 26th this year, defense attorney Franz Borghardt, also a defense attorney in the other case, accused the victim of lying and game playing, saying that she would have called for help if she actually felt uncomfortable. At one point during the altercation, an LSU, so the school, police department officer, walked up to the victim's car and asked if she was okay. WBRZ reported that Donald Steele shooed them away before taking the victim to a more private location out of view of that officer. The defense claimed because she never called anyone for help on her phone, which she had, nor did she take advantage of the LSU police questioning the scene, that she probably was not scared and the encounter was either consensual or friendly. You know why she didn't ask for help? Because she didn't need help. It was consensual, said attorney Borghardt. However, Assistant District Attorney Cummings said that a victim videoed Steele's police unit and was texting her friend about what was taking place, and this evidence is shown during the trial. Cummings said that Donald Steele is a hunter. He was preying on her. All of the evidence shows his intent to prey on her. So they set sentencing for this verdict of guilty of malfeasance of office for April the 30th. The victim has also filed a civil lawsuit against Steele. Despite repeated calls of my client being a liar, the fact that Donald Steele was found guilty today shows she's telling the truth, said the victim's lawyer, Ron Haley, after the trial. That's on March 26th. I didn't say any judge's name in there, but I'm going to tell you a secret. The judge's name is Ebony Johnson Rose. So the reason I bring this up is because she lets him off on the felonies, right? She lets him off on felony second-degree kidnapping, felony, misdemeanor sexual battery, and finds him guilty of a misdemeanor malfeasance in office. And she sets sentencing for April. You follow me?
Yes.
There is no such charge as misdemeanor malfeasance in office.
Yep.
So Ebony, same judge, comes back in April 18th and essentially realizes that she has convicted this officer of a crime that does not exist. So WAFB picks it up on April 18th, 2024, and here's what they have to say. A post-conviction debacle in the 19th Judicial District was settled after a district judge chose to acquit a former officer of sexually inappropriate behavior with a woman he was sworn to protect and serve. District Judge Ebony Johnson Rose threw out malfeasance charges against former Baton Rouge police officer Donald Steele Jr. Thursday, April the 18th, after she initially convicted him on the charge in late March. Prosecutors and defense attorneys asked for that judgment to be put on hold one day after the judge issued the verdict. At issue, they argued was that the issue that they're arguing over is that the judge convicted Steele of misdemeanor grade malfeasance. Even though the charge is considered a felony in state law, there is no misdemeanor grade malfeasance in office. So Franz Borghardt released a statement after the sentencing hearing saying the defense team expected the outcome. The judge's decision confirms what we always knew and fought for. Donald Steele is innocent. I have no comment on what he's saying here. Reports to the contrary were premature and did not take into account the court's determination that no sexual battery occurred. The state does not have the right to appeal an acquittal. In the event they attempt to, we look forward to maintaining the court's declaration of Mr. Steele's innocence in any and all forms. District Attorney Hiller Moore called the judge's actions unprecedented and said his office will seek a review of the judge's decision in the appeals court. Steele was initially arrested in August of 2021. The case made its way through the system. A grand jury indicted him on account of second-degree kidnapping and a felony malfeasance in office. And for those of you who don't know, the kidnapping is always a felony. Steele waived his right to a jury trial, opting for a bench trial. By choosing the bench trial, so this is different because you're just going to have the judge. That means that Judge Ebony Johnson Rose has complete authority over deciding whether enough evidence of improper behavior was present to secure conviction on these two felony charges. During the 2-day bench trial, Steele's accuser gets on the stand, testifies that she drank alcohol before getting behind the wheel one night in June of 2021. This is according to all court documents. And the accuser testified that she was driving away from her apartment complex and Donald Steele pulled her over. She testified that he told her he would not give her a ticket because she was, quote, too pretty. Then she told the court that Steele took her phone and used it to airdrop photos of her to himself, turn off her location settings, and put his contact information into her phone. According to court records, Steele's accuser also testified that 2 LSU Police Department officers attempted to get involved in the stop but left after briefly speaking with Steele. One of those officers testified in court that Steele told him he was giving directions and told the officers the accuser was his sister. Steele's accuser told the court that he threatened to arrest her unless she followed him to another location. The cop led her to a warehouse near a Baton Rouge Police Department lot on Chippewa Street. Steele's accuser then testified that Donald Steele touched her chest without her permission and propositioned her for sex, even offering to pay her for favors and find others who were willing to pay her for sex as well. Steele's accuser told the court she was only able to leave the scene by agreeing to meet up with Steele later after he had finished his overnight shift. The victim then told the court she ignored messages from him once she was home and got away from him. Officers testified that Steele did not turn on his body camera during the interaction and even went as far as to power it completely down when it unintentionally activated. Judge Johnson Rose decided that Steele was not guilty of second-degree kidnapping and convicted him on the misdemeanor grade of malfeasance. And after the ruling, she met with the defense attorneys and the prosecutors privately. And according to a post-trial brief filed by defense attorneys, Judge Johnson Rose gave the impression that, and they changed her name throughout all of this. It's not me. It's like multiple sources call her Judge Rose and Judge Johnson. They gave the impression that the court found issues with the credibility of the accuser's story and implied that prosecutors had not met the full burden to convict Steele of malfeasance. Defense attorneys wrote that the argument made by prosecutors had fallen apart like a house of cards because the prosecution had not proven any battery had occurred. Steele had been fired from the Baton Rouge Police Department after an internal affairs investigation. So this is the same judge that we've been talking about in this case. And like, look, I get what she's saying, but I think you either hit him with a felony or you let it go. I don't know if he's guilty or not, but I can't imagine that is going to be a good follow-up for I made a new verdict up.
She made a new crime up.
But I'm saying in the other case, she like went back and like reinstated a verdict. In this case, she
right. And so this guy was indicted on felonies. It sounds like she was like sort of convinced, but not completely, or she didn't want to convict him of a felony. So she's like, I'm just going to make this a misdemeanor, right? Like I said, a judge that would do something like this, they're never going to realize the difference.
Yeah, it's bizarre. I had one more judge for today, but I'm not. Go ahead. I'm sorry. I interrupted.
I was just going to say that I feel like that the Honorable Ebony Johnson Rose should take a good look at the situation and ask herself if it seems like she should continue being a judge.
I mean, look, I've seen judges make a lot of interesting choices. The interesting part about what I've watched judges do in general is the bulk of them learn pretty quickly that this is serious business and they need to be up to the task. I don't feel like that's what's happening.
The less you do, the better, honestly. Judges are supposed to be there sort of like to referee almost. In this case, she was serving as a finder of fact, right? But it was finder of fact with regard to what he had been indicted on, not the crime she made up.
Yeah. And I just find it interesting that in both cases, she is essentially compromising the verdict.
She is. She's actually substituting her own opinion for what has been found otherwise, right? Because even in a bench trial, there's a certain process that has been gone through, right? Where you've got a grand jury indictment. They didn't. Well, obviously, they're not going to indict a misdemeanor to begin with, right?
Right.
But especially one that doesn't exist. In doing that, it is her. I feel like it's a judge exercising like what a judge can do but shouldn't do.
Yeah, it's just these two, like, they're not small mistakes. These are not like administrative errors. These are like, this is like legislating from the bench in a way.
Well, yeah, she made up a crime. She's like, you didn't quite hit the felony level, so I'm going to just hit you with a misdemeanor. But that's not what exists as state law, right?
Yeah, maybe her future's in legislation.
I don't think that's a good idea either. Sometimes you have to do less, right? There is she certainly should be competent to make the call on whether or not the facts, the evidence supports the requirements to find the defendant guilty, right? Now, granted, I presume that the defense filed a brief drawing attention to the fact that she had convicted him of a crime that didn't exist, right?
Oh, yeah, that's the starting point.
I assume that's what it was, right?
Yeah.
And so, at that point, what do you do? Because like that, you're right. It's not small. This is ridiculous. And it's
well, you can't even walk it back at that point if you've acquitted him of the felonies. And
well, I guess, yeah, that would have been an
double jeopardy.
At least she did learn that, I guess.
I don't know, but I mean,
having that's why you don't. I mean, it's kind of complicated because state laws often they have sort of stipulations that like when you charge first degree homicide or first degree murder, like that encompasses all of the lesser charges that could possibly go along with that, right?
Yeah.
And so in that situation, usually it's, you don't present all of the options, but they're all included in that like one indictment, right? So, if it ends up being second degree murder, it's still valid on a first degree murder indictment, right? Because the way that it's set up is to encompass such.
Yeah.
I can see that line of thinking here. As far as, I don't want to give him a felony for this, right? Just a little slap, not a big one. Except it wasn't even an option, right? It wasn't just not an option because he wasn't indicted for it. It was not an option because it didn't exist at all.
Right.
And so these are things that it doesn't really make sense. And it seems like at least eventually the other courts that are hearing these and they're making these comments about it, they're saying like, this is crazy. What's she doing? Right. I mean, because there's mistakes in understanding stuff all the time, but this isn't her misunderstanding something. This is her saying, this is what I'm going to do.
Yeah. Well, it's interesting because her name kind of gets left out of the first one. The jury trial one, ultimately, she only comes up because they do have to renew it de novo to a degree. that's related to Bridget's case. And while they're looking at that, she's attached to it. But what they're really focused on is whether this mistrial made sense. And I think Judge Hines, who after Judge Johnson Rose recuses himself, Judge Hines just kind of throws it into oblivion by saying, "Oh, it's a mistrial," and that part
it got to be retried.
That's where they were headed. But essentially, the First Circuit held it up, and then they turned around, and while it was on the calendar for retrial for the felonies, this Louisiana Supreme Court said, "Wait, hold up," to the defense, asking them, like, is this the way we're going about this now? And that was sort of the end of it. There's no reason for it to be retried now because the acquittal, essentially what they did is they reinstated the acquittal and said, you can't actually like take 2 or 3 bites at the apple at this. Like once you say it and the court rules, that's it.
Correct. And I would say, I can't quite say never, but almost. It's never going to be the case where the judge is going to overturn a jury verdict from acquittal to guilt. It's going to go the opposite way if it ever happens.
Yes. Yeah, that's generally what you see, yes.
Right, because in the event, because honestly, that's what justice requires, right? And because, if 12 people looked at it and they didn't see proof of guilt, right, at least to the extent that they wrote it on the piece of paper and handed it in at the end, right, you can't possibly then substitute your judgment for that and put somebody in jail. Now, if a judge were to sit through a trial and know without a shadow of a doubt that there was not enough evidence, and there's no way that people that are actually fulfilling that oath could have possibly found this person guilty, they could enter a verdict and set aside the jury verdict, right?
Yeah.
But that is almost always going to be on the side of acquittal, not guilt.
Yeah, so I think the way that works is there's a process in civil trials called a judgment notwithstanding a verdict. Now, that's where a judge can enter something else other than what the jury finds. But that type of action would actually violate a defendant's Fifth Amendment right, like to not be in double jeopardy, and
Right.
the Sixth Amendment right because the defendant chose to have a jury trial, not a bench verdict.
Right, but like I said, it's almost always overturning guilt. And I don't think a defendant is going to argue being acquitted when they were found guilty otherwise.
Yes.
And so, again, that's it. So there is no violation there, right?
No, but no, there's no violation of the Fifth or the Sixth at that point. But I will say, okay, say it's a serious murder trial. The jury comes back and finds him guilty. Whoever the defendant is, they are found guilty. And so they're convicted. And a judge pulls a judgment notwithstanding verdict and basically says, I don't think that this happened in the way that the prosecution has not met their burden.
Right. That's the difference. It's not, I don't think, the evidence has not been presented.
Right. So the evidence has not been presented. The state has not met their burden. Ever how they phrase that there, it's limited. But I will say this. That is the only time that a prosecutor in the United States can appeal a judge's verdict like that would be if they had an issue. So that could be reversed. A judge could find you, quote, not guilty after a jury convicts you. An appellate court can reverse that. They can send it back. But I think the only way that you can appeal is after a guilty verdict. And I think the way that works. Yeah.
Because otherwise, think of the endless cycle there.
Right.
Okay. our default setting here in the United States as citizens is freedom. All right. Anytime our freedom is taken away, like by putting us in jail, we have processes we can go through to regain our freedom, right? To put it back to default. And so, freedom is where we're at. And it's never going to be a case where you're going to need to be appealing your freedom because that's the default setting.
Yeah.
Does that make sense?
Yeah. And like there's other, like I know, like there's a person that hits my inbox when I talk about some of these things. I know they're going to say like there's some other things there. I'm going to go ahead and acknowledge there's some nuance to this, the judgment notwithstanding verdicts. But I stand by what Meg just said because that's accurate. Like the whole idea here is your rights are being protected to the extent that like the process is preserved and your rights are preserved.
There's absolutely cases where some sort of big, technicality or loophole could be addressed on appeal. And that would be more of a technicality or a loophole being addressed than like a situation where, the verdict was changed or whatever. That's a whole different thing. And like I think was stated, and it was either in one of the articles or the opinion where they were talking about, they were suggesting like one of the justices was giving sort of unsolicited and uncouth, and like they were saying basically like that judge was really dumb, and he was saying like we need to be more diplomatic about this because we are to correct mistakes, right? And that's true. And that it's never going to be a situation where like the appeals court can't hear it. That's where you go. But, to a certain extent, there's never going to be a situation where, they're going to be like, well, the jury said you didn't do it, but I say you did. That's just not going to be the case. And the state is not going to continue that because an acquittal is an acquittal. Now, interestingly, that is why when a jury is hung, there is a mistrial as opposed to like they just, acquit the person.
Right.
Because that can be retried. That's a very significant difference, right?
Yep.
All right. Well, now that we're done with Law 101.
Well, I had this
101.
I had this other judge, but I think it's got to wait because, like, even you and what you found on it, like, what you read was mostly redacted, right? So I guess.
Sorry, were there words on that?
Either that or you're just texting me black sheets of paper. It's a possibility. I don't know.
I mean, it was heavily redacted, but
I'm going to come back to that one because the reason I say that is because I think there might be something mental health related there. And if that's the case, or if any of the accusations that are like, I don't want to beat up on somebody while they're down. And if something like what is described really has happened to them, I feel like that's kind of I feel like it'd be kind of a bad move on my part to bring them up.
I feel like the decision was sound either way, but we can talk about that later.
Okay. Thank you so much for listening today. We'll see you next time.
This is True Crime XS.
All right, so I'm going to tell you guys a few things about some of the folks who are helping sponsor our show. Now, Labrati Creations sponsors our show, and you can always use the Crime XS code there. You can also just message them at Labrati Creations, and they will generally do something for the people who come from True Crime XS. They were our very first sponsor. They've done a lot for the show, and that code is CrimeXS at LabratiCreations.com. The first new advertisers that we have, and I've selected all of these guys. I've selected all of these advertisers. So the very first one is Cure. Now I'm going to tell you guys about this, about Cure as being one of our sponsors. If you're an athlete, you know that proper hydration is key to peak performance, but plain water can be boring and sports drinks can be filled with artificial ingredients and added sugars. That's why we love Cure. It's a clean and effective way to stay hydrated and perform at your best. I use it late in the day when I switch out of caffeine mode. Specifically, when I hit the pool or I go play tennis with my wife, I use Cure to help me stay hydrated. It helps me recover after a long day. Now, you guys may not know this, but I build things. And right now, I've been building several structures on our property out here. Among those is a new podcast studio space for myself. I do a lot of that work at night and into the wee hours. And I always have some Cure with me to go into my aluminum water bottle. Hydration is not just about filling up my aluminum bottle with water. Cure Hydration is an oral rehydration solution that contains the perfect balance of electrolytes and glucose to help your body absorb water and rehydrate quickly. Whether I'm building things or putting the podcast together or chasing these dogs that you sometimes hear in my studio up and down the trails to get them worn out, Cure Hydration is the way that I choose to go. Cure Hydration is an oral rehydration solution, or an ORS, that contains the perfect balance of electrolytes and glucose to help your body absorb water and to rehydrate quickly. The formula is made with all natural ingredients like coconut water powder and pink Himalayan salt. It's free from artificial flavors, from sweeteners, and preservatives. Cure Hydration is vegan, gluten-free, and non-GMO, making it a great option for anyone with dietary restrictions or preferences. The packets are convenient and easy to use. You just mix them with your water and you drink. They're perfect for on the go. They're perfect for travel. And anytime you need a quick and effective hydration boost, ready to combat dehydration, then you try Cure today and feel the difference for yourself. You can use code TrueCrimeXS for 20% off your order. That's TrueCrimeXS. I have a link that I'm putting in the most recent episode show notes, and True Crime Access will get you 20% off. Our second sponsor for the show today is Laird. Now, Laird has a list of things that they want me to tell you about. They have better ingredients with amazing taste and functional benefits. They have a superfood creamer crafted from the highest quality, all-natural, real food ingredients. All Laird products are sustainably sourced and thoroughly tested to ensure that you're incorporating the cleanest, finest fuel into your routine. They have all natural whole food ingredients, and they contain naturally occurring MCTs made from coconut oil. There's no artificial flavors, there's no colors or additives, and there's no sugar from highly refined corn syrup. They want me to talk about my love of coffee, but the truth is, I don't do much with coffee. But let me tell you someone who does. My wife has to have a cup of coffee every day. Now, I've fallen off recently, but one of the big things that I've done since the beginning of our relationship is she used to go and get a Starbucks every morning. I have substituted that out by always trying to make her coffee. It's not going to be every single day of time from when I met her, but for the most part, almost every day, I make her coffee. I put her creamers together, and I make sure that she has a good way to start her day. So with Laird, he started experimenting with his morning ritual almost 2 decades ago. He found that when he started adding fats to his morning cup, like coconut oil, he had amazing energy throughout the rest of his day. He gradually perfected this recipe for an epic cup of fuel, and he began sharing it with his friends in the surf community. I'm an ocean guy, so I saw this item and I was like, okay, we're going to try this one out. Are you ready to feel more energized, more focused, and supported? Go to lairdsuperfood.com and add nourishing plant-based foods to fuel you from sunrise to sunset. And you can use our promo code at checkout to save 15% off your purchase today. Our offer code for this for Laird is going to be TrueCrimeXS. Pretty much everywhere except for Labarte Creations, if you use TrueCrimeXS, that will get you, at Laird, it'll get you 15% off. At some of the other places, they'll get you 20%. And the last sponsor I want to tell you about is Zencastr. We are part of Zencastr's creative network. We've been using Zencastr since about midway into our first season. Meg and I experimented with a lot of different ways to put the podcast together. And the truth is, Zencastr, an integral ingredient to us being able to bring you this show. It's so easy. It's now super easy. You can record a podcast with Zencastr. You can log in using your browser and you start recording a high quality podcast right away. You can record studio quality sound and up to 4K video with your guest. You get to feel a sense of zen, knowing that Zencastr's multi-layered backups ensure you will always have your recordings in the highest quality, even if the connection is unstable. You sound your best. I mean, if you've ever worried about what you sound like, Zencastr's post-production process makes you sound buttery smooth. It automatically removes those ums and ahs in your recordings. It removes those awkward pauses in conversation too. You can set the right podcast loudness and levels while reducing background noise with a click of a button. That's how you don't hear my dogs every second of every episode. Zencastr is all in one. If you've thought about podcasting before and realized that you need a lot of different tools and services, those days are now over. With Zencastr's all-in-one podcasting platform, you can create your podcast all in one place, and you can distribute to Spotify, Apple, and other major destinations. Just go to zencastr.com/pricing and use my code TrueCrimeXS, and you're going to get 30% off your first month of any Zencastr paid plan. You can also check out the other plans they have available. I want you to have the same easy experiences that I do for all my podcasting and content needs. So zencastr.com/pricing. The offer code is TrueCrimeXS, and it's time for you to share your story today. We are also adding New Era as a sponsor for the show. New Era Cap is a headwear and apparel brand founded in 1920 in Buffalo, New York. Now, I actually have some experience with New Era caps. My dad and I have been through multiple iterations of baseball caps through the years. We collect different styles, different eras, and now my teenager has started his own cap collection and has several New Eras as the centerpieces. Our favorite teams may not be the same, but our outfits are all topped with the same New Era ball caps. We love the quality and the ability to wear what the players are wearing. Not to mention, New Era is the leading headwear manufacturer with quality licensed products. You can support your favorite college or pro team in style from the official headwear provider for the MLB, NFL, and NBA. You can get a stylish accessory for your everyday ensemble and support True Crime XS. Just shop the official headwear and get 15% off when you go to neweracap.com. That's neweracap.com/truecrimexs. You can also use the code TrueCrimeXS at checkout. That's it. That's all you have to do. And that's 15% off your order using the promo code TrueCrimeXS.